Well, this is what happens when all of your attorneys and your high-up officials are just sycophants and suckadicks. You get this kind of incompetent bullshit, like, having to throw out the James Comey and the Letitia James indictments because they were like blatantly vindictive prosecutions. Yeah, So I know the Department of Justice is going to appeal. Anyway, this is just as bad. New York Times analysis finds errors in the Trump Supreme Court filing that calls for National Guards in Chicago. The Trump administration has claimed that the police were slow to protect federal agents on October 4th, but videos and audio show that their rationale conflates hours of events involving a shooting, a protest, a car crash, and a police radio call. The Trump administration, this is by Devin Lum, Matthias Schwartz, and Christopher Kodal. And Ainara Teufelsfather? God, that's a long name. The Trump administration made erroneous claims to the Supreme Court, mischaracterizing the responsiveness of local police and actions of protesters in a filing asking the justices to sign off on the deployment of hundreds of National Guard troops to Chicago, a New York Times investigation found. The emergency request filed by the Solicitor General John D. Sauer, which draws John D. Sauer, another one of his criminal fucking defense attorneys. Yeah. Now the Solicitor General for the Supreme Court. Yeah, it really pays to lose cases for him, huh? I guess it does. The emergency request, which draws heavily from court declarations made by two Homeland Security officials, misstates what happened in the aftermath of a car crash and shooting on October 4th in Chicago that involved Border Patrol agents. A Times analysis of hours of police radio and hundreds of videos posted to social media refutes the federal government's claims that the Chicago Police Department didn't respond quickly to the scene, leaving federal agents to fend for themselves during what they called a riot. That contention is central to the administration's legal rationale for deploying the National Guard. That violent protests are preventing agents from enforcing immigration law. The Trump administration appealed to the Supreme Court on a fast-track emergency docket after lower courts granted Illinois' request to block the troop deployment. The court could rule any day. If the justices decide in favor of the Trump administration, the emergency ruling, although temporary, could lay the legal groundwork for the deployment of National Guard troops to more U.S. cities. The chaotic events in Chicago began when a resident, Miramar Martinez, was honking, yelling, and aggressively trailing an SUV carrying Border Patrol agents to protest their presence. The two vehicles collided in a neighborhood on the southwest side of Chicago, and an agent then shot her 5 times while she was in her car. Ms. Martinez, 30, drove a mile away and called 911. A protest formed at the scene where she had been shot and lasted for hours. About 90 minutes after the shooting in the same area, a civilian car rammed into Immigration and Customs Enforcement vehicle. Now, how the police responded to these events is bitterly disputed between Chicago officials and the Trump administration. A key element of the administration's argument appears to hinge on a police radio call. After federal agents requested assistance with the protest, a Chicago police officer told one district that "we're not responding to the scene." Mr. Sauer apparently refers to this call in his filing, writing that the Chicago Police Department's initial refusal to respond was emblematic of a troubling pattern where local forces provide a tepid response at best when federal officers are attacked and obstructed. But the filing claimed that police officers didn't respond for more than an hour after the shooting, wrongly implying that the call took place just after Ms. Martinez was shot, when in fact it was 2 hours later. The filing also falsely suggested that the entire police department was told to stay away from the site. Additionally, it portrays protesters as aggressive throughout the day. The Times investigation found that the Chicago officers responded to the shooting within 7 minutes and were present at the ensuing protest, while at 12:30 p.m., one police district was ordered not to respond to the protest. Other districts sent officers to the scene. The analysis also found that the protesters were peaceful for the first 2 hours before a forceful federal response. The administration cited the declarations by Homeland Security officials 30 times in its Supreme Court filing. The veracity of those declarations was questioned by a district court judge in her opinion granting a temporary block on the Chicago deployment. Judge April Perry noted the officials' potential lack of candor and questioned their ability to accurately assess the facts. The Supreme Court will decide based on filings alone, without oral arguments or the trial judge building a clear factual record, and likely with the police investigation still ongoing. It's also likely that more evidence about October 4th will emerge and be contested during the district court trial. The Homeland Security Department stands fully behind the testimony we gave in this case, which was under penalty of perjury. Really? Because the first thing that they wrote in their official statement was that Martinez had a semi-automatic rifle in her car and was pointing it at the officers, and that's why they shot her 5 times. When it became clear that she had no such thing. She did have a carry permit, and she had the gun in a holster that she never even pulled out. So they're liars. They lied. And then they rewrote the fucking statement. So, okay, Tricia McLaughlin, a spokeswoman for the Department of Justice. A White House spokeswoman referred to questions to the Justice Department. A spokeswoman for the Justice Department declined to comment. A Chicago police spokesman declined to answer questions from the Times, but said an internal investigation was ongoing. The Times fact-checked 3 claims in the Trump administration's filing about October 4th. Here's what the evidence shows. Claim: the police did not immediately respond to the shooting. That's inaccurate. The filing states the police in Chicago eventually responded more than an hour after the shooting. Officers responded within minutes of the shooting at 2 locations. First, officers went to the site that Ms. Martinez drove to after she was shot. A police radio recording showed they reached her within 4 minutes. Around the same time, federal agents flagged down a police car near where Ms. Martinez was shot. Radio communication showed that officers were at that site by 10:36 a.m., 7 minutes after the shooting. Additional officers arrived 12 minutes later. By 10:55 a.m., footage shows that at least 4 patrol cars have arrived. The footage, along with other videos analyzed by the Times, has since been removed from social media. For over an hour, officers secured the scenes as dozens of onlookers, protesters, gathered. And at 11:34 a.m., a Chicago officer relayed a message from the chief of patrol telling officers that they were handing over to federal agents at both locations. Videos show officers leaving the shooting by 11:55 a.m. Approximately 5 minutes later, and 7 blocks north of the shooting site, a driver filmed a black SUV crashing into a white pickup truck driven by an ICE agent and pushing the vehicle off the road. A Border Patrol vehicle pulls up behind the civilian vehicle, and those 2 vehicles also collide. Police report shows officers were notified about the ramming at 12:12 p.m. Footage from police body cameras and bystander videos shows 9 officers arriving on the scene about 10 minutes later. Mr. Sauer's assertion that the police did not respond for an hour after the shooting was based on a court declaration provided by Russell Holt, the then director of ICE's Chicago field office. The Times analysis shows that there are discrepancies in both Mr. Hott's account and Mr. Sauer's summary of it. Mr. Hott refers to the police district's 12:38 p.m. were not responding call multiple times in his declaration. In one case, he gets the timing right, providing a timestamp and transcript for part of the call. But he also erroneously reverses the timing of the call and of the ramming of the ICE trucks elsewhere in the document. Mr. Sauer then jumbled the timeline in the administration's filing to the Supreme Court. Claim: the police refused to assist federal agents. This needs context. The filing states the initial refusal of the Chicago police to respond to the October 4th shooting is emblematic of a troubling pattern. One police precinct close to where Ms. Martinez was shot, the 9th District, did not respond immediately after federal agents requested backup at approximately 12:30 p.m. But another district dispatched officers around the same time as the request. At 12:24 p.m., a dispatcher for the neighboring 8th District asked cars to report to the shooting site. The dispatcher mentioned that the 9th District, which had been responding earlier in the day, was backlogged. A few minutes later, a 9th District dispatcher reported the federal agents were requesting assistance. So anyway, you get where I'm going here. This goes on and on about claims that the rioters were throwing objects. They weren't. There was nothing found. No body cam footage, no other video that shows that they were throwing things. Hours of live streaming they look through. They can't find that. So, of course, the Trump administration is once again lying to the court. This time in an absolute emergency ruling that they sent all the way up, which won't have any oral arguments. They'll have to just decide on the merits of the filing. So if the Supreme Court is still showing deference to Dear Daddy Donnie Duty Pants, then Chicago's in trouble. And the rest of these blue cities.